The concept of a dying declaration is a poignant example of how the law grapples with the weight of final words. When an individual faces imminent death, their statements about the circumstances surrounding their impending demise carry a unique gravity. This essay delves into the legal intricacies of dying declarations, exploring their definition, forms, evidentiary value, and the conditions under which they can lead to a conviction. Central to our discussion is Article 46, subsection 1 of the Qanun-e-Shahadat Order 1984, a legal provision that lays the foundation for understanding dying declarations. We will navigate the requirements for admissibility, emphasizing the paramount importance of voluntariness, completeness, and truthfulness. Further enriching our exploration is the perspective of Islamic law, which provides its own insights into the significance of dying declarations. By examining both legal frameworks, we can gain a comprehensive understanding of this crucial legal concept. Join us as we unravel the complexities of dying declarations, shedding light on their profound impact on legal proceedings and the pursuit of justice. Article 46, subsection 1 of the Qanun-e-Shahadat Order 1984 serves as the cornerstone for understanding dying declarations in legal proceedings. This provision carves out a specific exception to the rule against hearsay, permitting the admission of statements made by individuals who believe they are about to die. The rationale behind this exception lies in the belief that a person approaching death is unlikely to fabricate falsehoods. The solemnity of the situation, coupled with the prospect of facing a higher judgment, is thought to compel truthfulness. Article 46, subsection 1 stipulates that such statements are admissible when made about the cause of the declarant's death or any circumstances leading to it. This encompasses not only the immediate physical acts, but also any events or actions that contributed to their fatal condition. However, the admissibility of a dying declaration is not automatic. The court must be satisfied that the statement was made under a sense of impending death, with the declarant aware of their grim fate. The law recognizes that the weightiness of such a belief fosters a heightened sense of responsibility and truthfulness. A dying declaration is a solemn utterance, a final testament made by a person staring death in the face. It's an exception to the hearsay rule, admissible in court due to the gravity of the circumstances surrounding its creation. Imagine a victim, fatally wounded, using their last breaths to identify their attacker. This is the raw, powerful essence of a dying declaration. The rationale for its admissibility rests on the belief that a person on the brink of death is unlikely to lie. The imminence of their end, the weight of their words, all point to a compelling truthfulness. The law recognizes this, understanding that such statements can provide crucial evidence, especially when the victim is the only eyewitness. However, not every deathbed utterance qualifies as a dying declaration. It must relate directly to the cause or circumstances of the declarant's impending death. For instance, a statement about an unrelated financial dispute wouldn't hold the same weight. The dying declaration stands as a poignant intersection of life and death, where the law seeks truth in the shadow of mortality. Its admissibility hinges on the belief that in the face of death, truth prevails. Dying declarations, these poignant whispers of truth, can take on various forms, each echoing the dire circumstances of their utterance. The law, in its compassionate embrace, recognizes that the fragility of life may not always allow for a formal declaration. Written statements, meticulously crafted, can serve as powerful evidence. Imagine a victim with trembling hand, penning down the details of their assault, knowing it might be their last act. This tangible proof, imbued with the weight of their final moments, speaks volumes in the court of law. Oral declarations, often gasped out in the throes of pain or fading consciousness, carry a raw, undeniable power. A muttered name, a whispered accusation, all become crucial pieces in the puzzle of justice. Even in the absence of words, the language of despair can convey truth. Gestures, nods, and even signals can constitute a dying declaration. Imagine a victim unable to speak, pointing towards their assailant with their last ounce of strength. These non-verbal cues laden with meaning can speak louder than words. The law in its wisdom acknowledges these diverse forms, ensuring that justice is served even when death silences the victim's voice. Section 5. Recording the declaration, capturing the last words. The solemn responsibility of recording a dying declaration falls upon anyone who happens to be present at that critical juncture. Every word uttered, every gesture made could hold the key to unraveling the truth behind a crime. A magistrate, arriving at the scene, might find themselves tasked with capturing these vital pronouncements. Their training equips them to elicit information carefully, ensuring clarity and accuracy in the face of distress. Police officers, often the first responders, play a crucial role in preserving these fleeting moments of truth. Their presence of mind and adherence to protocol are paramount in ensuring the admissibility of such declarations in court. Doctors, battling to save a life, may also find themselves in the position to record a dying declaration. Their medical expertise allows them to gauge the patient's consciousness and assess the veracity of their statements. Section 6. Islamic law and dying declarations as sacred testament. In the realm of Islamic law, dying declarations hold a revered position, considered a sacred testament delivered on the precipice of the hereafter. The gravity of facing one's Creator amplifies the sanctity of these final words. The Quran, the holy book of Islam, underscores the importance of truthfulness, especially when death approaches. It emphasizes that falsehoods hold no place in the presence of Allah, especially when one's soul is about to depart. Within Islamic jurisprudence, dying declarations are admissible as evidence, subject to certain conditions. The declarant must be of sound mind, aware of their impending demise, and the statement must pertain to the circumstances of their death. The sanctity attached to dying declarations in Islamic law stems from the belief that at the cusp of death, a person is least likely to lie. It reflects the profound respect for truth and justice that permeates Islamic legal tradition. Section 7. Essentials for admissibility, pillars of truth. For a dying declaration to be admissible in court, it must stand on a bedrock of authenticity and reliability. Several essential conditions, acting as pillars of truth, determine its evidentiary value. Voluntariness is paramount. The declaration must flow freely from the declarant, devoid of any coercion, influence, or prompting. Any hint of manipulation immediately casts a shadow of doubt over its veracity. The court must be convinced that the declarant was of sound mind and understanding at the time of making the statement. Delirium, confusion, or the influence of medication can cloud judgment and render the declaration unreliable. Completeness is crucial. A fragmented or incomplete statement lacking essential details can hinder the pursuit of justice. The court needs a clear and comprehensive account of the events leading to the declarant's demise. The cause of death must be directly related to the content of the declaration. Statements about unrelated matters, while potentially important, do not carry the same legal weight. The declaration's focus must remain on the circumstances surrounding the fatal event. Finally, it is essential that the declarant has, in fact, passed away. If they survive, their statement loses the unique status of a dying declaration and is subject to different evidentiary rules. These conditions, meticulously crafted, ensure that only genuine and trustworthy dying declarations are admitted as evidence. Section 8. Evidentiary value, the weight of final words. Dying declarations, these poignant echoes of a life nearing its end, carry significant evidentiary weight in legal proceedings. However, they are not treated as conclusive proof, but rather as a crucial piece of the puzzle, subject to careful scrutiny and corroboration. The weight accorded to a dying declaration rests upon the compelling presumption of its truthfulness. A person on the brink of death is believed to be free from worldly motives and earthly desires, making their words carry an inherent ring of truth. However, courts exercise caution, recognizing that even in the face of death, human fallibility can taint recollection or perception. The circumstances surrounding the declaration, such as the declarant's mental state, the presence of any influence or the possibility of misunderstanding, are meticulously examined. Corroborative evidence plays a vital role in bolstering or refuting the contents of a dying declaration. This might include witness testimonies, forensic evidence, or any other relevant facts that support or contradict the declarant's account. The court, acting as the ultimate arbiter of truth, carefully weighs all the evidence presented, including the dying declaration, before arriving at a just verdict. Section 9. Conviction based on dying declarations, a solemn verdict. While a dying declaration holds significant evidentiary weight, securing a conviction solely on its basis requires careful consideration and a high threshold of certainty. The law recognizes the gravity of taking a life based on the words of a deceased individual, demanding a meticulous examination of all surrounding circumstances. A dying declaration, even if deemed admissible and reliable, seldom stands alone. It forms a crucial thread in the tapestry of evidence woven together by the prosecution. Corroboration is key, with independent evidence playing a vital role in strengthening the case. For instance, if a dying declaration identifies an assailant, supporting evidence such as eyewitness accounts, DNA evidence linking the accused to the crime scene, or a history of animosity between the accused and the deceased, significantly strengthens the prosecution's case. Conversely, inconsistencies within the declaration itself, contradictions with other evidence, or doubts about the declarant's mental state at the time of making the statement can cast a shadow of doubt on its reliability. The judge, entrusted with the solemn duty of delivering justice, must consider all these factors before reaching a verdict. The standard of proof, as in all criminal cases, remains beyond a reasonable doubt, a high bar that reflects the gravity of a conviction. Section 10. Conclusion: the enduring significance of dying declarations. Dying declarations, these poignant whispers from the edge of existence, hold a unique and enduring significance in the realm of law. They stand as a testament to the enduring human quest for justice, even in the face of mortality. The law, in its wisdom, recognizes the weight of these final words, granting them special status as an exception to the hearsay rule. The solemnity of the circumstances, the belief that deathbed pronouncements are imbued with a unique truthfulness, forms the bedrock of their admissibility. However, the law also treads cautiously, acutely aware of the potential for error, fading memories, or even deliberate manipulation. Stringent conditions for admissibility, the need for corroboration, and the high standard of proof in criminal cases all reflect this caution. As we conclude our exploration of dying declarations, we are reminded of their profound impact on legal proceedings. They offer a voice to the silenced, a chance for the departed to contribute to the pursuit of justice. In the intricate dance between life, death, and the law, dying declarations remain a poignant reminder of the fragility of life and the enduring power of truth.